Can a single, overlooked detail completely flip the script on a multi-million-dollar lawsuit? You're about to find out. This isn't just a story about money. It's a masterclass in how the smallest piece of evidence can become the most powerful weapon in the courtroom. Welcome back to our channel, where we dissect the most mind-bending legal battles in history. Today, we're diving deep into the case of Transdata versus a major tech giant, a lawsuit that seemed like a sure thing until one tiny, unexpected clue changed everything. It all started with a patent. Transdata, a smaller tech firm, held a patent for a wireless meter reading device. Think of it as the smart meter on your house, but this was the early version. They accused a massive energy company of infringing on this patent, essentially stealing their technology for a nationwide rollout. The stakes were astronomical. Transdata was demanding hundreds of millions of dollars in damages. For them, this was a David versus Goliath battle. A win would mean financial security for decades. A loss could mean bankruptcy. In the initial trial, things looked incredibly promising for Transdata. Their legal team was sharp, their arguments were compelling, and they presented what seemed like an airtight case. They showed how the energy company's system was nearly identical to their patented design. The jury was convinced. They sided with Transdata, awarding them a staggering amount of money. The courtroom erupted. The smaller company had done it. They had taken on a titan and won. But here's where our story takes a dramatic turn. The legal world knows that a verdict isn't final until all appeals are exhausted. The tech giant, with its deep pockets and army of lawyers, wasn't going down without a fight. They immediately filed an appeal, and that's when the real detective work began. The appeal process is where lawyers re-examine every single piece of evidence, every testimony, every document. The energy company's new legal team started digging. They were looking for a crack, any inconsistency they could use to challenge the verdict. They pored over thousands of pages of technical documents, depositions, and internal emails from Transdata. Weeks turned into months. They were searching for a needle in a haystack. The pressure was immense, the clock was ticking, and hundreds of millions of dollars were on the line. The breakthrough came from the most unlikely of places. It wasn't in a complex technical schematic or a smoking gun email. It was hidden in plain sight on an old page of Transdata's own website. While scouring the internet for any information about the company's history, a junior paralegal on the defense team stumbled upon an archived version of Transdata's About Us page from years earlier. The page included a photo. It was a simple, low-resolution picture of the company's founder, proudly holding up his invention, the wireless meter reader. It was the very device at the heart of the lawsuit. At first glance, the photo seemed harmless, just a standard corporate picture. But one of the lawyers, a guy with an eagle eye for detail, noticed something odd. He zoomed in on the photo. He zoomed in again, and there it was. In the background of the picture, barely visible behind the founder, was a calendar hanging on the wall. The calendar was turned to a specific month and year. And that date was more than a year before Transdata had filed their patent application. Why was this so important? Well, in patent law, there's a critical rule. You K1 patent something that has been publicly disclosed or offered for sale for more than 1 year before you file. This single photo was a bombshell. It was potential proof that Transdata had publicly displayed their invention long before they were legally allowed to, if they wanted to secure a patent. If the defense could prove that this photo constituted a public use or an offer for sale before the critical date, the entire patent would be invalid. And if the patent was invalid, the whole multi-million-dollar lawsuit would crumble into dust. The legal team knew they had something huge, but they had to be careful. A grainy photo from an old website isn't exactly ironclad evidence. They needed to corroborate it. Their investigation went into overdrive. They started tracking down everyone who might have been at Transdata's office around the time the photo was taken. They were looking for anyone who could confirm that the device in the picture was the actual working invention, not just a prototype. They deposed former employees, business partners, even the photographer who took the picture. The founder of Transdata, under oath, was questioned relentlessly about the photo. He initially dismissed it, saying it was just a mock-up, a non-functional model for a promotional shot, claimed the device in the picture couldn't actually do what the patent described. But the defense team kept digging. They found old marketing materials and brochures from that same time period. These brochures described the device's capabilities in detail, matching the patent claims almost perfectly. They even included language that suggested the product was ready for market. This was the offer for sale evidence they were looking for. The photo wasn't just a picture of a prop, it was part of a larger marketing effort that happened too early. The pieces of the puzzle were coming together. The calendar in the background provided the timeline. The marketing brochures provided the context. The photograph tied it all together. When the case went to the appellate court, the atmosphere was completely different. The tech giant's lawyers presented their new evidence. They put the enlarged photo on a giant screen for the judges to see. They pointed to the calendar. They showed the corresponding marketing materials. They argued that Transdata had, by its own actions, forfeited its right to a patent. They had publicly showcased and offered their invention for sale long before the one-year grace period allowed by law. Therefore, the patent at the core of the lawsuit was invalid from the very beginning. Transdata's lawyers fought back, of course. They argued the photo was ambiguous, that the device wasn't fully functional, that the brochures were just promotional fluff. But the evidence was too compelling. The combination of the dated photograph and the specific claims in the marketing materials created a narrative that was impossible to ignore. The appellate court judges were persuaded. In a stunning reversal, they overturned the original verdict. They agreed with the defense. The patent was invalid due to the prior public use and offer for sale. The multi-million-dollar award was erased. Just like that, Transdata's victory vanished. This case sent shockwaves through the world of intellectual property law. It serves as a powerful cautionary tale for inventors and entrepreneurs everywhere. The lesson is crystal clear. Be incredibly careful about when and how you disclose your invention before filing for a patent. Single photo, a casual conversation at a trade show, an old page on your website, any of these can come back to haunt you and invalidate your most valuable asset. The on-sale bar, as it's known in legal circles, is an absolute defense. For the big tech company, it was a massive victory snatched from the jaws of defeat. All thanks to a diligent paralegal and a lawyer who knew the importance of looking closer. For Transdata, it was a devastating blow, a fortune lost because of a simple marketing photo from years ago. This story is a testament to the fact that in law, the devil is truly in the details. And sometimes, the most powerful evidence isn't a secret document, but something that's been hiding in plain sight all along. It proves that no matter how strong your case seems, you can never be sure what a determined legal team will uncover when they start digging. The truth, as they say, will out. What do you think? Is this a brilliant piece of legal detective work, or a tragic loss for a small innovator? Let me know your thoughts in the comments below. If you enjoy stories about high-stakes legal drama, make sure to hit that subscribe button and ring the bell so you don't miss our next deep dive. Thanks for watching, and we'll see you in the next video.